Oh, hey guys, I want to talk to you about a case I've just recently become aware of, but it follows a train of thought I've been developing for a while, which is that the new Supreme Court, the makeup of it, and the leanings of it, the way it interprets the Constitution, is going to lead to all kinds of changes in the way cities can do revitalization, planning, land use rights. There's just so much there. Uh, you know, this court has a lot of liberals' tits in a tangle. Uh, for example, um, I mean, it's been 15 years ago, but Justice Scalia wrote an opinion in Heller versus District of Columbia, which pretty much overturned a lot of gun control. He pointed out that the American Bill of Rights is based on the English Bill of Rights, dating from about the 1650s, which granted the right of all Protestants to own arms, including firearms, for the purpose that the Parliament could call them up in the event the king tried to force Roman Catholicism as a state religion. Parliament could call them up, have the militia overthrow the king, and put a Protestant back on the throne. Um, what this did was show that our Second Amendment clearly had the idea that the common people could rise up at the instigation of a legislative body and overthrow a tyrannical president or executive. Um, and so, pretty much, it said, any adult man between 1755 was the militia, um, and could own common weapons. Flip side of this that doesn't get discussed a lot is it distinctly mentions that the militia is always under civilian control of a legislature, and so that these things out there floating around that call themselves militias are really brigands. And abortion rights, you know, was it Alito that wrote the most recent opinion? He pointed out that in English common law, early American common law, there's a variety of opinions as to when life begins. They're usually rooted in Jewish or Christian ideas, religious ideas, in which there's a realm of opinion range of when life begins. Uh, Conception is not the clear favorite there. But the point is, there's no right to abortion anywhere in American law prior to uh, Roe v. Wade. So Roe v. Wade was thrown out. That same kind of interpretation leads things like Euclid and Ambler, which underpins zoning, up in the air. But also, in the case of Geraldine Tyler versus Hennepin County, Minnesota, which is Minneapolis, a 93-year-old woman owed $2,300 property tax and $12,700 in fees, and the county evicted her from her property, seized the property, tax foreclosure sale, sold it for $40,000, and they pocketed that $25,000. What this suit says is going back to the Magna Carta, or even before that, in the legends of Robin Hood and the English culture. It was understood that the government cannot take you for more than you owe. If they take property in excess of what you owe, they have to pay you fair market value for it. So far, state Supreme Courts have ruled one way or the other, and even different U.S. appeals courts have ruled one way or the other, but a very conservative set of organizations is backing this lawsuit, including the Libertarian Cato Institute, National Taxpayers Union. Basically, it would limit the power of city and county governments to take your property for tax delinquency. They can take it to pay off your debt, but as far as taking it, putting it in a land bank or something like that, if it's worth more than the debt, they have to pay you fair market value. This land reuse agency that's proposed, even possibly some of J.B. McCuskey's ideas, seem to be affected, jeopardized by this. The case will be heard April 26th of this year. I don't make too many predictions about how that will go. I'm not a lawyer. I would just say that given this court's tendency to accept arguments going way back into English or even pre-English law, it's very possible we'll be looking at a whole new paradigm of land rights and urban revitalization in the United States. I'll holler at you later.